I want to say at the outset that it is an honor for me to be here among friends and people who share my vision of what we will hope will be, and I quote, a country and region that are free of corruption. For those of you who may not know, and those of you who know, that is an excerpt from the mission statement of Transparency International Trinidad and Tobago. And I took it, and while I was preparing my speech or discussion or conversation with you all this afternoon, I realized how much I share the same goal, that I too want to see a country and region free of corruption. Any conversation on corruption should start with a definition of what is corruption. However, for this discussion, we will agree that corruption is something we know it when we see it or we hear about it. Corruption can be both tangible and intangible. Bribery, extortion, misbehavior in public office, and fraud are some examples of what corruption is. To get consensus on what corruption will take several hours, and time does not permit me to do so this afternoon. If I were to ask everyone in this room what is the cause of corruption in Trinidad and Tobago, I would receive several different answers or opinions, and judging from the quality of the audience before me, I would receive answers like governments, PNM, UNC, COP, etc., lack of effective and efficient checks and balances, lack of effective regulations, no accountability from both public and private sectors, just to name a few. Ever since I can remember, corruption has always been on people's lips. John O'Halloran and the DC-9 scandal bring back memories of the first scandals I heard about. Since then to now, no public official has been sentenced for corruption except Magistrate Jagasa, as far as I can remember. It seems as though securing a conviction based on corruption in Trinidad and Tobago is near impossible. In the case of former Prime Minister Basdio Pandey, he was charged for failing to declare certain bank accounts under the Integrity in Public Life Acts in 2002. The case dragged through the courts from September 2002 to 2012, when a magistrate stayed the prosecution of the criminal charges because, in her view, the proceedings amounted to an abusive process, and discharged him. For the years 2011 to 2012 and 2012 to 2013, there was zero number of criminal indictments relating to corruption that were disposed of before the High Court. Reading an article in the Daily Express dated the 9th of September 2016 by Brent Winter, attorney at law, entitled, and I quote, "The Leaves Are Broken," Mr. Winter states that, and I quote, "We are sitting on a time bomb due to the backlog in criminal cases." He goes on to state that, and I quote, "During the 2014-2015 law term, 2,767 persons appeared before the High Court, the criminal court that is. 766 of those were charged with murder, while 2,001 were charged for non-capital offenses. Of that total, only 158 had their matters disposed of. 34 murders and 124 non-capital cases. Amazingly, it means that 2,609 accused persons were unable to have their cases determined, and these cases were thereby brought forward to the following law term, close quotation. Mr. Winter postulates that it would take 20 years to clear the existing backlog of cases, not taking into account fresh indictments being filed by the DPP daily. This statement has been corroborated by other attorneys who specialize in criminal defense work. In the case of Steve Ferguson and Ishra Galbransing, the two individuals named in a US money laundering indictment, the Attorney General signed the authority to proceed in 2006. They first of all challenged the authority to proceed. That challenge went to the High Court, Court of Appeal, and the Privy Council refused leave. The matter then started before the Chief Magistrate in 2008, where the evidence was heard, and they were committed to be extradited in 2008. They also challenged the main evidence in the matter. That matter also went to the High Court, Court of Appeal, and Privy Council. They lost all their appeals. They even challenged the constitutionality of the Extradition Act. This application was also dismissed. The Attorney General signed the warrant for return, and it was challenged based on the fact that the charges pending locally were similar to those that they were indicted for in the United States of America, and they argued that the warrant should be quashed. A High Court judge on the 7th of November 2011 agreed with them, and the matter was dismissed. There was no appeal by the then UNC-led government. After 5 years and millions of dollars, the case came to an end. And oh, by the way, the two men are financiers of the United National Congress. And they have always admitted that, and they have never denied that fact. And further, all the other co-conspirators who pled guilty in the US have since served their term and are now out. Some have even paid compensation to the government of Trinidad and Tobago with millions of dollars. Let us not forget the Section 34 debacle, where after public outcry, Transparency International issued a joint statement on the 19th of September 2012 saying, and I quote, "It is clear that a deliberate attempt was made to deceive our parliament and by extension the citizens of Trinidad and Tobago," close quote. This statement was supported by the Joint Consultative Council, Fixing TNT, the Federation of Independent Trade Unions and NGOs, and Trinidad and Tobago Manufacturers Association. We have another high-profile extradition to the US, seemingly destined to follow in the same course. We have had commissions of inquiry where the only benefactors seem to be the attorneys who charge gross sums of money for their services. The Piarco inquiry, the Uffa inquiry, Clico inquiry, Las Ultras inquiry, the Hindu Credit Union inquiry, the 1990 attempted coup inquiry, and I could go on. In an article dated 8th of September 2016, the Newsday stated that it was, and I quote, albeit unconfirmed, that the Commissioner Ibrahim would receive $1.5 million, fellow commissioners would receive $750,000, lead counsel for the Commissioner, Ms. Elder, would receive $1.5 million, and Jagdeep Singh would receive $1.2 million. What have been the outcomes of these inquiries? The last Commission of Inquiry, Las Ultras, the Prime Minister stated that there was no finding of criminal liability by anyone. What benefit has the country derived from this huge expense to taxpayers? The DPP asked that the Clico inquiry be stayed until his investigations were concluded. Did the DPP see a potential conflict? Has a report revealed an issue that would not have been uncovered by the investigation? Why do we continue with these commissions of inquiry when the only punitive action, when no punitive action can be taken by the Commissioner when the main target fails to appear before the Commission? Trinidad and Tobago does not lack the legislative teeth to fight corruption. We have several pieces of anti-corruption legislation. The Prevention of Corruption Act 1987, the Integrity in Public Life 2000 as amended, the Proceeds of Crime 2000 as amended, and we now have the Public Procurement and Disposal in Public Property Act 2015 awaiting to be proclaimed. We have bills laid in Parliament, that is the whistleblowing bill, and recently the Attorney General has now found voice to talk about civil asset forfeiture. We have signed also many international conventions. We are signatories to the United Nations Convention Against Corruption. We are also signatories to the Organization of Economic Cooperation and Development. We have signed the UN Nations Convention Against Transnational Organized Crime, and we have also signed the Inter-American Convention Against Corruption. With all these laws on the books, why is corruption so prevalent in Trinidad and Tobago? And why does corruption appear to thrive in our Twin Island state? In my view, because there is no accountability. Corrupt persons feel that they can get away with corrupt deeds. The investigations take too long, the prosecutions take too long, the appeal process can take years to complete, and if the appellant has the funding to go to the Privy Council, the process will be extended. There is also the issue that witnesses are either killed or lose interest because of the length of time it takes to prosecute. We have no proper functioning witness protection program. It is at best an ad hoc arrangement. Some of our parliamentarians seemingly have their own agenda, and it is not country first. It seems strange to me that you can pass a bill when in government, and when in opposition, you do not support what you brought to Parliament a few years earlier, and then seek to blame the current Attorney General for not doing research on whether or not the act was successful. I see no hope. There is no future for our young children if this type of third world politics continues. In the Transparency International Corruption Index report, Trinidad and Tobago was ranked at position 72 for 2015 as compared to 85th in 2014. True to form, we are among the most corrupt nations in the Caribbean region, with the likes of Haiti, Guyana, Dominican Republic, Suriname, Jamaica, and Cuba. The Corruption Perception Index stated that drugs, high crime rates, and political corruption were key contributory factors to overall corruption. The report also went on to mention that, and I quote, corruption has infiltrated the police force, close quote. From the inception of the Police Complaints Authority on December 29, 2010, there have been 2,139 complaints received. 1,279 are actively being investigated, and for the period 2014-2015, there have been 12 reports of police corruption, 297 serious reports of serious police misconduct, and 183 reports of criminal offenses by a police officer. I held a meeting with Mr. Carlos Ugaz, chairman of Transparency International, at the Police Complaints Authority office in March 2016. We were discussing corruption, and I spoke to him about corruption in Trinidad and Tobago. I mentioned that corruption had invaded every facet of life in Trinidad and Tobago. Every day you open a newspaper, there will be a story relating to either public or private sector corruption. No transaction, however noble it seemed, above board. There was always a motive behind someone doing something. It seemed we had lost our moral compass. Then, Mr. Ugaz asked me if I heard of the Commission for the Investigation of Illegal Groups and Clandestine Security Structures in Guatemala. I said no. He then shared his experience with me. And this is what I see signing of various peace accords. 12 years later, the country was plagued by organized crime, an ineffective criminal justice system, weak institutional governance, and a lack of political will and increasing crime violence. Does that sound familiar? Organized crime, an ineffective criminal justice system, weak institutional governance, and a lack of political will and increasing violent crime. Those are all the factors and elements happening right here in Trinidad and Tobago today. There were 6,000 homicides in Guatemala every year, and only 20% went to trial. Guatemala has a population of about 16.7 million people. In 2015, Trinidad and Tobago had a murder rate of 410. By the end of 2016, the figure may be approximately 436. Our population is 1.3 million people. Using the judiciary's annual report of 2014-2015, only 5.7 criminal cases go to trial. That is, using their figures, 158 matters were disposed of, which I spoke about earlier. 276 persons were listed for hearing. Divide that and multiply by 100, you get 5.7%, compared to 20% in Guatemala. So we are actually worse off than Guatemala in terms of persons going to trial. It was reported in the Gleaner newspaper out of Jamaica on September 13th, 2016, that only 15% of court cases were concluded last term, and that's criminal cases also. That is March 2016 to July 2016. 578 cases were listed for trial, and only 90 of those cases were heard. In Guatemala, after constant pressure from an NGO group, a drive was launched to persuade the government to establish a body to investigate their crimes. And I was very happy to hear the chairman, Mr. Murray, say that Transparency International has that respect of the people and of institutions. And where I'm talking now, I'm speaking to transparency to push this drive forward. In 2003, the government of Guatemala asked the UN Department of Political Affairs to provide assistance to the state to investigate and prosecute these criminals. On January 7, 2004, the UN and government of Guatemala signed an agreement to provide for the establishment of the Commission for the Investigation of Illegal Groups and Clandestine Security Structures. There was strong opposition and widespread controversy. Of course, you'd expect that. The Constitutional Court's opinion were requested on a number of points. The court held that some of the provisions were unconstitutional, but the government redrafted the agreement. On December 12, 2006, there was an agreement to establish the International Commissioner Against Impunity in Guatemala between the UN and the government of Guatemala. This agreement was ratified by their parliament. The initial mandate has since been renewed 3 times in April 2009, January 2011, and April 2015. Its current mandate concludes in September 2017. It allowed for the first time an independent international body, the UN, to be given the authority to act as complementary prosecutors in criminal proceedings in national courts. The Commission investigates and supports criminal prosecutions that fall within its mandate. The mandate can be investigations and/or prosecutions dealing with white-collar offenses, for example. Most importantly, the prosecutions and court decisions are the responsibility of the state of Guatemala. To quote from the Washington Office on Latin America in June 2015, their report, in sum, it is an international organization established to investigate and support the prosecution and dismantling of criminal networks under Guatemalan legislation and within the Guatemalan justice system, whose goal is to build capacity in local institutions. If the government and opposition want to hold crime talks, I suggest this is the only talking point that needs discussion. Like Guatemala, we need an international commission against impunity or corruption in Trinidad and Tobago. The benefit of this would lead to an efficient, transparent system of criminal justice where no political party, no businessman, and no citizen can claim any bias. A special court can be established to deal with corruption-type matters as to avoid undue delays with daily sit-ins. Best of all funding comes from various contributions made by different countries. A trust fund was created in Guatemala, which was administered by the UNDP. There is no funding from government or citizens, and this guarantees the independence of the Commission. Now, what better method do we have to institute in Trinidad where we have a free, it could be free, we could have independent investigators coming down, independent prosecutors at no cost to the government that will allow us to then investigate matters that the government, that the parliament determines what is their mandate. There could be no bias, so everybody should feel free to allow this to happen. The Commission will also work to strengthen the country's public policy framework and fortify the justice sector institutions. The Commission also takes proposals for legal reforms, works closely with staff of the Director of Public Prosecutions and the Trinidad and Tobago Police Service to enhance expertise in criminal investigations and prosecutions, and provides technical assistance to these and other justice sector institutions, for example, the Forensic Science Center. The Commission is a hybrid mechanism and shows what can be done once there is political will for the rule of law to prevail. The goal is to leave the country's constitution in a stronger position with new in-house capabilities to tackle similar cases in the future. In Guatemala, technical assistance included judicial reform, witness protection, telephone tapping. There was also an agreement for security and justice topics, and these were, for example, policies of an international framework for security, police reform, which we need in Trinidad, prison reform, we know we need in Trinidad, policies and institutions of casual investigations and anti-corruption investigations, administration of justice, arms control, private security and service company, sound communication and participation, legislative agenda, commitment to act together with the signature of agreement. All of this has led to tremendous success in Guatemala. The former Minister of Interior was sentenced to 3 years on June 13, 2014 for offenses of irregulation of procurement procedures, and also to the government orders was sentenced to 1 year imprisonment. On the 6th of June 2014, the Chief of the National Police Service of Guatemala was sentenced for life for the murder of 7 inmates in 2016, known as the Pavon case. On the 5th of June 2014, the retired military official, he got sentenced for 5 years and 3 months on a charge of embezzlement. The corruption case against the president, Alfonso Portillo, he stole $20 million from the Ministry of Defense. He fled to Mexico, but was extradited to Guatemala to face trial in 2008. He paid a fine of a mere $130,000 US. However, Portillo was extradited to the US in 2013 for laundering $70 million through the US banks. He pled guilty in 2014. I have shown you that our criminal justice system as it stands today is slowly grinding to a halt. With an escalating crime rate, underpaid, overworked prosecutors, backlogs in both the magistrates and high court, crime and criminals thrive. While some commentators state that cases take too long and judges are too cautious for fear of being appealed, our support institutions cannot keep pace with the increase in demand. For example, the Forensic Science Center, where it takes years to get a certificate of analysis for a firearm. It on average is about 3 to 4 years. There's also the lack of courtroom availability to hear the cases. One only needs to read today's Guardian newspaper, pages A5, A6 to 8, to see the different opinions on why our legal system is grinding to a halt. For the years 2011 to 2015, the Financial Intelligence Unit, the FIU, has analyzed 2,341 suspicious activity reports with a dollar value of approximately $3.7 billion TT. And to date, there has been no convictions of any person relating to money laundering offenses in Trinidad and Tobago. Following her arrest on money laundering charges in 2012, Vicky Boudram is still before the magistrate's court in San Fernando. Other persons charged with money laundering offenses are still before the magistrate's court. All of this has not gone unnoticed by the Financial Action Task Force or the Caribbean Financial Action Task Force, where Trinidad has now been placed on the International Cooperation Review Group. If we do not put our house in order, we then face the reality of being put on the grey list. I have showed you a way forward. I have outlined a methodology that appears to be working in Guatemala, a country that had similar problems to ours. You, Trinidad and Tobago Transparency International, and other NGOs with similar goals have to be that NGO to approach the government and say, we have a way forward to fight corruption at no cost to the taxpayer. In 2010, the Guatemalan mission to the UN in New York explained the purpose of and achievements of the Commission over the last 4 years. At the UN headquarters in Vienna, the Commission's model was again presented to the representative missions around the world. And one of those countries there was Trinidad and Tobago. Our politicians know about the Commission for the Investigation of Illegal Groups and Clandestine Security Structures in Guatemala, and they know of its success. However, as far as my research is able to show, to date, not a word has been spoken about the Commission as a mechanism for tackling corruption in Trinidad and Tobago. It is up to Transparency International and other NGOs represented here today to bring it to the attention of the government and opposition, and that the public do not trust national institutions because they feel the institutions have been corrupted. An independent international body like the Commission established in Guatemala is the only way forward now, in my view. In the recent Nigel Henry poll that was published in the Express stands a testament to the fact that persons in Trinidad do not trust the institutions. Therefore, in my view, if Guatemala can do it, surely we can do it also. Thank you very much, ladies and gentlemen.